Welcome, everybody. Thank you for being here with us today. We have a great presentation. Today, we are going to be hearing about what's the difference between a special needs lawyer and a special needs financial planner. What a great topic, and we have a great speaker that they are going to explain to us what is this difference. But before we start with our presentation, I'm going to talk about Partner Resource Network. My name is Veronica Alvarez, and I'm the Regional 13 Coordinator for Partner Resource Network. So Partner Resource Network is the parent training and information centers for Texas, and we are funded by the Department of Education, specifically OSEP, the Office of Special Education. We provide free resources and information for parents of children with disabilities and youth with disabilities that we call self-advocates. Our mission is to empower and support the families that are impacted by disabilities or special healthcare needs. We serve parents of children with disabilities, youth with disabilities from the ages to 0 to 26. And now we have 4 projects serving parents. We have the PAT project, the TEAM project, the PEN project, and the PAT project. But we all are the family of the same agency, Partner Resource Network. I'm part of the TEAM project in the red area, the Region 13. We serve Austin and surrounding areas. And another region of TEAM is San Antonio, Region 20, and also Region 1. We are part of TEAM project. Our services are free, and we offer parent workshops, webinars, youth workshops, information and referrals, one-on-one technical assistance, supporting the R meetings and IEP consultation. We do once a year a symposium. We offer parent leadership training, youth leadership training, and access to social media resources. So for today, housekeeping. So your video and your microphone is off. So if you have any question, please type it in the chat box or in the Q&A, and we will be answer your questions during the presentation. This presentation is being recorded. We are going to post a link in our Facebook pages, and also Allison is going to share. They have a YouTube channel, and they also are going to share that video in there. At the end of this presentation, you are going to receive a link with a survey or evaluation about our presentation. Please do so. It only takes you 1 or 2 minutes to fill it out. With that information, we have your feedback, and we can report to our grant and continue giving you guys free resources and services. So we do not provide CEUs, but I can do a certificate of attendance. If you need one, please type it in the chat box or email me, and I can do that. I can give you a certificate of attendance. So again, this is my contact information, Veronica Alvarez, my phone number. Notice that we have a new email, region13prn@gmail.com. And please visit our webpage at www.prntexas.org. We have a lot of information in our webpage. All right, that's it for me. I'm going to stop my share, and now I'm going to present you guys our awesome speaker we have back, Allison Schaberg. Like you know her. We were working with Consolidated Planning Group for a year now, a little more than a year now. So we have her very often. She's a financial planner, and she's a passionate advocate for the special needs community. She has a lot of experience. She is also a mom with kids with disabilities. So thank you for being here, Allison. And also we have Miss Melissa Donovan. She's a lawyer. She's here in Austin with the group Willwell Law Firm. and she's going to be talking with Allison about the presentation. So let's start. What is the difference between a special needs lawyer and a special needs financial planner? Thank you, ladies, for being here.
Thanks, Veronica. Thanks for having us. As always, it's a pleasure to be back with you and the families that you serve. And it's always a pleasure to be here with Melissa Donovan. This is a topic that comes up a lot. There's, in the community, the special needs community, as parents, there is so much that we have to know. And most of the things that we have to know are complicated. And there's some things that there's not an easy fix for. But one of the things, Melissa and I put this presentation together, I don't know, earlier this year, probably in the beginning of the year, sometime. And because what we found in our practices is that there seems, in this community, there's a lot of confusion on the differences of what a special needs financial planner does and what a special needs attorney does. So basically what happens in both of our practices, people call Melissa on the financial side of the house, and people call me on the legal side of the house. And the truth is that we really work closely together. But when you have a special needs loved one, really, you need both. And so today what we're going to do is we're going to talk a little bit about the differences of special needs planning and a special needs attorney, how and when we come together, and essentially when and where do you need us, basically. And I summarized the whole presentation of when it comes to the legal side of the house, I say that the special needs planning attorneys, they're the paper, they're the legal documents, they're the things that you have to have, right? But then we're the money in the right bucket. So we're going to talk more about that, and I'm going to turn it over to Melissa. Melissa, thanks for being with us today.
Thanks so much. Always fun to have you on board and be here with you, Allison. And for your note, Veronica, I think it'll make it easier. The firm's about to change their name, so no one's going to have to figure out how to say "we will" anymore. That's always an issue. So, but Allison makes the perfect point in the very simple, phrase that she just said, is that she's the money, we're the paper. I know lawyers hate being, called the people that just do paperwork, but that really does kind of get the point across. And the goal with any planning regarding any kind of clients, particularly clients when you're dealing with special needs children, is getting the entire team together, making sure everybody is on the same page. And that's why it's really important that you're working with someone like Allison and an attorney, so that the entire plan can come together and you've got the proper planning in place and the money to actually carry it through, which I would highly recommend talking to Allison about money and not myself.
I one of the things that I like in special needs too, it's just similar from a medical perspective. If you have something wrong, like major, if you have something wrong with your heart, or if you have cancer or something like that, you go to a specialist. You don't go to a generalist. You definitely don't go to a podiatrist for heart issues. Same thing with a special needs family member. Unfortunately for us, our situations are specialized. They are tricky. There is special care that needs to be taken in all of these situations, and that is why when it comes to there are such things as financial advisors. We all know that, and there's all kinds of different types of attorneys out there. But when it comes to special needs, there are certain advisors and certain attorneys that are specialized in that. And I always like to say that when it comes to special needs, this is not a DIY. I know we have a lot of DIY do-it-yourselfers out there, and unless you're really, really nuanced in that, because of the critical mistakes that you could make along the way that could cost you thousands or hundreds of thousands of dollars over the years of the life of your loved one with special needs. So one big thing that I'm a huge advocate for, again, we're not attorneys. We don't play one on TV either. But we do really, really make solid recommendations for attorneys that are specifically nuanced in special needs, as opposed to a generalized, a generalized attorney, because again, there's so many rules and laws that are ever changing. You know, the UT Special Needs Law Conference, it happens every year. It happens every year because there's so many changes and things that are happening in the state of Texas as it relates to the rules and laws and things like that. So that's why it's really, really important to be working with a professional that is nuanced in that. So when it comes to a special needs financial advisor, certainly we provide financial advice. We have the same licenses that most financial advisors have. When it comes to how we work, it could be fee-based or it could be commission-based. A special needs financial advisor is able to calculate future care cost estimates. So when you have a loved one that might have care needs for the rest of their life, not just the rest of yours, that's a big deal. That's a long time. And it's like another retirement. So if you're married, you've got a husband and wife, we've got 2 retirements. It could be 25 to 35 years, but your loved one may have care needs 25 to 35 years post your death. So having proper estimates and doing them sooner versus later, so that way you can plan for that ahead, is really, really important. We're able to help you with that. Another thing that we do is I use the phrase, ensure that you have the money in the right buckets to protect benefit eligibility. That is so critically important. And honestly, a lot of families and many of the families that we work with don't necessarily know that, because they have minor children that have basically never qualified for anything. You make too much money. Your kids don't qualify for SSI or Medicaid. And so you didn't necessarily know about some of the restrictions and where to have money, where you can have money, to where it won't be counted against you for future benefit eligibility for SSI and Medicaid, for instance. So we're able to really do some forecasting to make sure a family is able to retire and pay for the future care. And because that's such a big number, that forecasting is really, really important. We're also, able to just, provide the best advice on which vehicles are going to help you reach the goals. And again, the power of time. I always say it's not about looking back. You're here today. It's not about looking back about what you haven't done or what you should have done or anything like that. Don't even beat yourself up about it. I don't even like talking about that with people. You are where you are. And it's about kind of, moving things in the right direction, for that going forward.
Yeah, no, I couldn't have said it better myself, Allison. You always want to look at this as, the different things that you can do moving forward, and not necessarily, like Allison said, many of people are going to be in a situation where your kids are not going to qualify for anything until, like Allison said, they are over the age of 18. But if you kind of get with someone early on, you can always have those conversations with Allison or someone like myself, so that you get a better picture of, okay, well, maybe my child's only 12 and I've got a ways to go. But if I'm talking to Allison now at my child's age of 12, I'm going to have a whole lot of a better picture of, okay, what do the next 6 years look like? And what do I need to do in the next 6 years to get where we need to be when my child does turn 18, so that we can do things like Social Security, guardianship if necessary, and where money should be even in the realm of guardianship, and what kind of guardianship do we need. There's so much stuff that goes into it. And I don't say that to scare anyone, because I know you all know there's kind of stuff that goes into it, but it's so much easier when you have someone on your side, on your team, that can kind of guide you along. Now, go ahead.
One thing I was going to say is that, we're nationally certified as Social Security advisors, and Social Security in itself is an animal that is like, oh my gosh, talk about people wanting to walk away from this, right? It is so complicated and so confusing. You throw in Social Security, RSDI, SSI, and all these terms that sound the same, but they're not the same at all. Those types of things. And as Social Security advisors, we actually have a specialized software that can help a family understand when and how to pull the trigger to maximize benefits for Social Security. Because the deal is, if your child has a disability that started prior to age 22, your child can be considered for childhood disability benefits under a parent's record. So when you retire or go on disability, they're going to be entitled to 50% of your benefit. And so this specialized software will maximize when and how to pull that trigger. And it's really, really important. And it's especially important because in our community, we oftentimes see families where they have one parent that might be a caregiver, right? They may not work outside of the home, so that caregiver may be also drawing off of another parent's record. So these calculations are super, super important. And so I just wanted to share that that's kind of like another one of those nuances that we really get in the weeds with. And that's where we're talking about the difference of hundreds of thousands of dollars and when and how to do those things. So these are just a few, a few of the things that, financial special needs financial planners can do. We always hear the buzzword of ABLE accounts. ABLE accounts came about back in 2012 under the tax code 529A. So we've all heard of 529Cs out there. But the 529A is for individuals with a disability that started prior to age 26. And this is a magic bucket that you can have assets in that won't disqualify them for SSI. And back in 2018, there was legislation that was passed that will allow you to convert your 529s to a 529A. Now it is limited to, $15,000 a year. So this is good. If you've got younger kids and you've got a 529C, you're not sure if they're going to go to college. We're always hopeful and optimistic, but we plan for the worst, hope for the best. But you can start converting those 529Cs to an ABLE account. And the cool thing about the ABLE account is you can pay for it if it's construed as achieving a better life for an individual with a disability. So you can pay for college out of that. You can also pay for tutoring and many, many other things out of an ABLE account. So if it's a big fat maybe on whether or not your child is going to go to college, then you may want to think about some of those things. But we're just very networked with the agencies across the state of Texas, across the U.S. that provide advocacy and resources for families with special needs. So we spend a lot of time talking about those resources and educating our families about what's out there, because there are a lot of programs for our kids, whether they're still minors or whether they have, transitioned into adulthood. So we spend a lot of time talking about that.
No, I think that's really great. And it's helpful here. Now, I know there are a few things, and Allison, you can kind of touch on it too, if you'd like to, but there are some ways that we do overlap a little bit, because you will talk to clients about the different benefits and SSI and Medicaid. And I usually refer to it as being the alphabet soup, because that's just how government programs work. It's like a giant letter jumble of everything. And those are things that your financial advisor, someone like Allison, who honestly, I sound biased, but it's quite rare. Being a special needs attorney, and I work with clients all the time, it is not very common actually that financial advisors have that level of expertise and specialization, particularly dealing with special needs, that someone like Allison does. So it's really, really helpful and really, really important that if you do have a child with special needs, that you're not working with someone who doesn't know enough about those programs to really be able to help you and guide you through them. Someone who is having that level of specialty really can make a huge difference in things. Now, like Allison had said, now for our side of things, I know most people think of lawyers as either being Jack McCoy or sitting behind a desk with a stack of paperwork in front of them, and that's all we do. We either fight or we write things, and that's about it. I like to think of my job as being a little different than that. They call us attorneys and counselors at law for a reason. And I kind of consider myself lucky that I get to use that counselor side of things a lot more than just the attorney side of things. But yeah, at a base level, my job as a special needs attorney is, yes, to discuss with clients what benefits are available and how does one actually become qualified for them. And also a big part of what we do is estate planning, but for various purposes. And in this realm of things, special needs estate planning. which could range from anything from, having parents who've never done wills, never done trust, don't have powers of attorney in place, and making sure you have all of that set up properly, and that you're not doing what I've seen so much in the past, saying, well, I have a special needs child, they can't inherit anything, so I'm cutting them out. I never, ever in a million years want to see clients do that, because it's not necessary. And that's where kind of special needs planning within your estate planning comes into play. For some people, we're talking special needs trusts. For some people, we're talking different forms of planning. It just kind of depends on the client. And that's the attorney's job, is to go through what your circumstances with you, what the needs are, and develop that plan so that you can get where you need to be in regards to where is your money going to go when you pass away? Are we worried about money coming in from other people now? Was there a lawsuit? Like did my child get injured and now there's a settlement coming in and we're worried about that settlement causing a loss in benefits that had already been on the table or would be on the table without it? So that special needs planning from an attorney perspective kind of ranges over a broad subject area. But a lot of it is what people would think of as being trust planning, estate planning, guardianships, which we talk about a lot. And one thing I always like to say is I think far too many people are under the impression that you have to have a guardianship for every child that has a special need, which is not altogether true. There are other alternatives, and it's really personalized based on the circumstance. But that's our job as an attorney, is to let you know, okay, what is your personal situation? What are the tools that we can use? Where can we get you in terms of those benefits to qualify someone? And then also, okay, are we looking at guardianship? Are we needing to go down that route at some point? Is it 6 years in the future? Is it 6 months in the future? That's our job as the attorney. And we do work quite closely typically with the financial advisors, because like Allison said, they know the money. And many times with my clients, when they do have special needs kids, I don't know if any of you can attest to this, but I'm guessing you can, you have enough on your plate. Am I wrong, Allison?
No,
Veronica.
Wait, I joke and say that that at my house we typically take 2 steps forward and 10 steps backwards is a typical day in the life at my house. But yeah, no, that is so true. There was 2 things that you mentioned, Melissa, that that kind of popped in my mind on the, cutting the child out. So yes, we've seen that. And then I've seen people say that they were kind of avoiding getting a special needs trust because they're leaving everything to the sister, and the sister is going to take care of either the sibling or the niece or nephew or whatever, right? And that is all fine and good, except for it doesn't usually work that way. Number one,
because sister never gets in an accident, or sister never gets a divorce.
Right. Like life happens in sister's life and it causes the money to go away. That's one thing that happens for the best people and the best relationships. Yeah. But the other bigger issue, even if your family is perfect, okay, which I know they are, is that sister providing a distribution to that child is income. Right. So when we're making distributions, it's got to come from a special needs trust or an ABLE account. People can't just write checks to people, with a disability and they just deposit it in their account, because SSI is going to count that as income. So that's a problem with that. The other thing that I wanted to bring up, and I know that we bring this up every time, so forgive me for being a broken record, but one big issue that we come across all the time is in the state of Texas. Oftentimes, not always, if you're in a divorce situation, oftentimes child support continues post age 18. And if it does, your child support needs to be redirected to a first party special needs trust, or it is going to be 2/3 of it is going to be counted as income for SSI purposes. So that is another reason and another thing that comes up on a pretty regular basis that people don't know about, and it accidentally messes their child up for getting SSI and Medicaid. So if that's you, if you find yourself in a divorce situation, you're getting child support post age 18, write it down. That child support needs to be redirected to a special needs trust. Can you talk about that a little bit, Melissa?
Yeah, sure. So basically what happens is that once your child is 18, the reason that you can get child support prior to your child turning 18 and it's not the end of the world for your child is that that's money to the spouse at that point. But once your child is 18, the government considers it your child's direct income, which is why if it goes to, even if it goes to mom, or if it goes to your child, or it goes to dad, whoever's getting it, if it doesn't go into a special needs trust, like Allison said, they're going to count 2/3 of it. That could potentially eliminate all of the SSI. The biggest problem is if you eliminate all of SSI for a lot of people, you're eliminating the bigger benefit, which is you're eliminating Medicaid. And that's always my biggest concern, and probably yours too, Allison. So I say simple solution, not I take that with a grain of salt, but the solution there is so long as you have in place what's called a first party special needs trust. Now with special needs trust, there's kind of a quadrant of how I like to explain how those work. There's a first party, there's a third party, there's a lifetime, there's a testamentary. So here, what we're talking about is a trust that is set up during your child's lifetime. It is technically their money going into it, which is why we refer to it as a first party special needs trust. First party meaning it is the child's money creating the trust. And the downside, which is not the end of the world, but it is a necessary part of it, is with any first party special needs trust, there will always be what is called a Medicaid payback provision in that. Basically, Medicaid is saying, we're going to allow you to qualify for these benefits by creating this trust. But because we are doing that, if there's any money left in this trust when that person eventually passes away, we have a right to be paid back for what we have to the extent that we can be. So with a first party special needs trust, so long as that money from the child support is going into the trust, the trustee of the trust can still use it to provide for things for your child, but it's not going to disqualify the benefits because they're not going to count 2/3 of that child support as being income. It's going into the special needs trust, and your child's going to be okay getting those benefits that he or she needs. Yeah, that's a really good point. And I do know you make it every time, Allison, but very, very good point.
Well, since it comes across our desk every week, I always want to tell people that because it's just something that's so commonly either not known or forgotten, and it creeps up. And the sad thing is, the truth is it might take 5 to 7 years for the Social Security Administration to catch up with you. And then they send you a letter and tell them, guess what? You owe us $100,000. Yeah. So we don't want that to happen. And so that's why we definitely bring it up over and over.
So like we've said previously, the whole thing with the special needs attorney, the special needs financial advisor is that, nothing, I always like to say things don't exist in a bubble. It's like one of my favorite phrases that I use a lot. And especially when it comes to special needs planning, it does kind of take a team a little bit. And people like Allison work with people like myself, with the family, so that we can make sure all of those puzzle pieces are there. And like Allison was saying, the money's in the right bucket. And do we need to have that first party special needs trust? Are we looking at life insurance funding a testamentary trust? So I know I used that term earlier. Let me clarify. Testamentary is just a fancy way of saying it doesn't exist until you pass away. We like to use fancy terms sometimes. That's our thing. Fancy words and letter jumbles. That's just all we lawyers do. But the way that works is that the plan is in place based on your situation. What do your assets look like as a family? What does your family situation look like? And then we kind of go from there. And Allison is there to make sure, okay, are we funding a testamentary trust? Maybe we're looking at some permutation of retirement accounts, life insurance policies. Maybe we've got several pieces of real estate. And I get that question from clients all the time. Well, what do I do with my houses? And what if I want my one kid to get the house and I want my other kid to just get cash? And those are all things that any decent advisor is going to talk to you through, because a plan is only so good, in my opinion, as it makes you feel like you have the peace of mind that you've accomplished what you want to accomplish and set your kids up in a way that you want to set them up. And
I
And
don't see,
oftentimes,
questions in the chat, but I have a question that probably I know the answer, but I want you to guys explain to them. You have the money for child support and goes to the first party, especially trust, but you need money for food and shelter. So do you pass the money to the able account and then the food and shelter, or how that works?
so yeah, and that sometimes that is a little complicated conversation. And well, let me back up first, because sometimes people ask me, can I leave my life insurance proceeds to an able account? And basically the answer is no. And the able account has a limit of $100,000 before you disqualify for SSI. So first things first, our kids have much higher care needs than $100,000. Okay. So a lot of times people ask us, why do I need a special needs trust and an ABLE account? And quite honestly, the answer is out of the ABLE account. So SSI is designed to pay for food and shelter. And if you're getting SSI and Medicaid, they basically don't want you to pay for food and shelter out of the special needs trust. Okay. You can pay for food and shelter like monthly rent or housing, mortgage payments out of an ABLE account, but you're really not supposed to pay for that out of the special needs trust if you're getting SSI and Medicaid. So that's one thing. So again, you can't leave your life insurance proceeds to an ABLE account. You can leave it to a testamentary special needs trust, and I want to talk more about that, Melissa, because I know there's a lot of confusion there, or a special needs trust. And so when she's talking about, and because this comes up a lot of the families that we serve have affluent parents or grandparents, right? And grandparents want to help their grandkids, or family members want to help. And they have your average financial advisor that doesn't know anything about special needs, and grandma and grandpa will accidentally leave large sums of money to your special needs child, which can be problematic. So first things first, a testamentary trust, as she said, forms upon your death. So it's not existing right now, but as soon as you die, it's set up. So this might be appropriate if your assets haven't arrived yet, if you're if you know for sure that there's family members that are never going to leave money to your special needs child. But if you know for sure that your special needs child stands to inherit large sums of money from other family members, explain how a testamentary trust doesn't work in that regard from a parent.
So what happens is that if you have a testamentary trust and that trust does not exist until you pass away, and grandma wants to leave money to your daughter, your son, I like to have names. It makes it easier to have the conversation and examples. So let's say you have a 12-year-old daughter and her name is Shelly. So grandma wants to leave Shelly money, and for some reason, grandma thinks it's a good idea. She's going to name the testamentary trust that you've created for Shelly. That trust doesn't exist. And if grandma, as we would expect, passes away before you do, there's no trust for it to go to because it doesn't exist yet. So the idea is, when we're having those conversations, similarly to what Allison was describing, we want to know, what does the entire family situation look like? Because if we do suspect that auntie or uncle or grandma is going to want to leave money to Shelly, then we're looking at a lifetime special needs trust. Now, this one, unlike what we were talking about earlier with child support, would be a third party special needs trust. The kicker is none of that money ever goes to Medicaid when Shelly eventually passes away. And that is kind of where also the connection to ABLE accounts comes in. When Allison was saying earlier, we get a lot of people that go, well, why do I need an ABLE account and a special needs trust? ABLE accounts, and I know sometimes I talk to people and they go, well, people say that ABLE accounts are bad, and they're not. I'm actually a very big fan of ABLE accounts, but I'm a very big fan of ABLE accounts when used appropriately and when used in conjunction with a special needs trust. Because if I have grandma who does want to leave $100,000 or even $50,000 to Shelly, I wouldn't really want grandma putting her money into an ABLE account that is then, if it's not able to be used, going to go to pay Medicaid when Shelly passes away, when it could have gone into a special needs trust that I set up, and I got to say, well, when Shelly passes away, that money goes to her siblings or their kids or whoever it may go to, but it's not going back to pay something that your parents, grandma's money never needed to go to in the first place. So that lifetime special needs trust acts as that bucket. We'll use that term again. I know it's your favorite term, Allison. So we'll use that term. It's the bucket that grandma's money can go into while you're still alive, and auntie's money can go into while you're still alive. That's where you can kind of place those gifts. Now, when we're doing trust with clients like that, we will always provide, sample letters so you can let them know, when you can have those conversations, because I don't know if you experience this a lot too, Allison, but in my experience, no one ever really wants to talk to their parents about what their estate plan looks like. That is not really a comfortable conversation for most people to have. Walk up to mom on Thanksgiving or Christmas morning and say, hey, Ma, what's your will say? What am I getting? Like, that's not the conversation that we want to be having. But when you do have a child that has special needs and you're concerned about these things, you do have to have those conversations, because you want to make sure that, your brother, your sister, your mom, your dad are not going to put your child in that position of saying, oh no, this is great, my grandma wanted to give me something, but now I've lost Medicaid. And now I've got to scramble to fix the problem, when if we just had the conversation to begin with and had that bucket set up, none of it had to happen. And those are things that we have those conversations with clients a lot about, kind of how to broach that topic, but it's an important conversation to have with your family members too.
So to address the question, because I don't think we fully answered the question, the answer is no, you don't leave the ABLE proceeds to a charity. So there's basically not, because there is a Medicaid payback on an ABLE account, they basically swoon in and get what they're supposed to get. And if there is anything left, then it's going to go to the estate of the individual. The owner, the child with disability, the individual with the disability is the owner of an ABLE account. So it would go to their estate, and however their estate is distributed, if there's any remaining funds after Medicaid takes theirs back, is where that goes. So if their estate says it goes to a charity, then it would go to a charity, but otherwise it doesn't work like that. Melissa, I just want you to address, so, because we see this every year, what happens if somebody accidentally inherits money, a surprise inheritance, then what happens?
So this does kind of hit back to special needs trust and ABLE accounts, because it all depends on how much money it is. That is actually one of the places where I say, when an ABLE account is used appropriately, I oftentimes advise my clients, and I'm not a financial advisor, I'm more so advising from that legal perspective of how the accounts work and ways to utilize them. But if, let's say, you inherit, or your child inherits $5,000, then if you have an ABLE account set up, that's the easiest solution if you haven't already funded it to the gift tax exemption. So just, I don't know if a lot of you may be aware of this, but with the ABLE accounts, they can be funded right now only a total of $15,000 a year. That will go up to 16 next year. It will track with the gift tax exemption. So if, let's say, you've already given $15,000 to that ABLE account a year, that's not going to work. We would have to create a first party special needs trust. But usually, in my experience with the majority of my clients, when they run into a situation where the dollar amount on the inheritance is under that $15,000, many times if the ABLE account is there, or even if it's not, you can quickly set it up. You can get it in there quickly. And so long as it's not in the child's name and account by, midnight at the end of the month that month, they will be okay. If that's not possible, because let's say it is $100,000 or it's $30,000, then we're looking at possibly maneuvering back into that special needs trust. And again, at that point, the thing that people, sometimes even I've had attorneys not realize this, it's your child's money at that point. So if we're doing a special needs trust because they've received that inheritance already, that estate has been clearing, it's going to go into a first party trust. Hopefully the money can be used during their lifetime, but it will have that Medicaid payback provision.
And there's no such thing as like disinheriting or not accepting the money. And like people ask all those types of questions. We had something else in the chat box, and in general, so she was saying that there was a special needs trust. There's multiple things kind of set up. And as far as a brother and the trust, the thing is all trusts aren't created equally. So if it's just a generalized trust, it's not a special needs trust. So I would say double check that. And I guess two things. With an ABLE account, from a financial perspective, we talk about it's all how you play the game, right? So we play the game with the ABLE account. So whether a person needs to put $15,000 a year in or not depends on how much money is in the child's name right now and how much we need to move to a certain spot prior to them turning 18. And also, the big thing is food and shelter. Again, a special needs trust doesn't pay for rent or mortgage payments. It could buy a house outright. An ABLE account can pay for that food and shelter. So if your child, and so here's the interesting thing, is if your loved one lives in a group home or a residential living facility, all of them bill differently. Yeah. So some of them bill as medical, some of them bill as food and shelter or housing. And then again, that's where you're going to need that ABLE account. And so when I say like it's all how you play the game, like for me, I have an ABLE account for my child with disabilities. And you know what we keep in there? 1 month's rent. So if something happens to her, Medicaid is getting 1 month's rent. So what? Because basically, you know, my daughter has enough to pay her rent, right? So that's just a backup in case she falls short 1 month, that the ABLE account can come in and pay that instead of course, as a parent, I could pay it. But if I go ahead and pay that, that could be construed as income to her. So that's why we do it. So that's an example of you could play the game. So if you know you have costs of $15,000 a year for shelter, for instance, then maybe that's what you always just keep in there, $15,000 or less. And, you know, other people have different scenarios. So it looks like our chat box is burning up. Veronica, I'll let you ask, you know, whatever you need to. You're on mute. I do that 10 times a day.
Sorry. We have a question from Jay. I'm in a situation with first party special need trust. Card accounting review is pretty detailed, down to a dollar amount. It is pretty bad headache. With ABLE account, is there an accounting review yearly? For Allison.
So I haven't seen somebody be sent that and ask for it. I think you can be at any point. And so in general, if you get a distribution from the ABLE account, it needs to be spent in the month in which you got it. And I don't mean a month from the date that you got it in the calendar month. And you should keep receipts and an accounting of what the distributions were for and keep those records. I myself have never been asked for the records, but you certainly can be. And Melissa, do you want to chime in on that?
So the only thing I would add to that, because that was actually pretty good answer, what I would have said too. But where you would want to be careful is if you are managing that account because you are guardian of the estate of the child, that can change things. Whenever the court is involved, whether it's through a first party trust and that trust was created through court creation, or you're the guardian of the estate of a child, the court is kind of inextricably intertwined with that and can require those accountings. But to just echo what Allison had said, the best thing that you can do, you want to always remember, if you're acting as trustee of a trust for someone, you're acting as a power of attorney for someone, you're acting as the guardian of the estate for someone, you are acting in a fiduciary role and you have certain responsibilities. And the biggest of those responsibilities is always going to be keeping good records and accountings. So it's just really important that you are taking that accounting. I see if you are only the guardian of the person, then those court accountings on assets of the estate are not in play at that point.
And also, honestly, you're supposed to really be keeping an accounting for SSI again.
Yeah.
I've not really seen anybody ever be asked for that ever. but they can. They reserve the right. I mean, I've seen them ask for your bank records for the last 3 months. I think I've been asked for bank records for the last 6 months before from SSI. But they could ask for accounting showing where you're paying for food and shelter out of the SSI. That is something that they could ask for. So just, the thing is, the honest to God's truth is SSI right now is $794 a month. Next year, it's going to be $841 a month. There was a 5.9% increase for 2022. And the reality of it is our kids are expensive, way more than $794 a month. Is that a joke? I mean, some people's out of pocket, just what they're paying for therapy in a given month is more than that, right? And so, just keeping track. What are you paying for medications? What are you paying for those therapies? Whether it's the out of network psychology or psychiatry appointments, or it's the ABA, whatever it might be. I mean, your kids some of your kids go to private school. Well, there you have it. That's expensive. So, I mean, these are, there's a lot of things out there you can keep track of, but our expenses are always far greater than what SSI gives.
Yeah. And I would just add to that, you don't have to be a QuickBooks expert to be doing this. You can keep a notebook. You can do whatever is simple for you, but you do want to make sure that you're keeping records of it. For people who haven't had to do it yet, when it comes to ABLE accounts and things like that, I kind of liken it, if you're familiar, if you have HSA accounts, it's kind of similar to that. Like if I have an HSA account and I'm paying for a doctor's visit and I'm taking and, paying from it for my HSA, generally speaking, the IRS is not going to ask me for that data, but they could. So it's just a good idea to keep those records. So I don't know if that's something that some of you are kind of familiar with, that you're not used to the ABLE account, kind of track that mentality over. That can help.
And I think it's a whole nother topic, and I that we can talk about another time. We do have webinars on guardianship, partial guardianship, the difference between a guardianship of the person versus guardianship of the estate. And honestly, that's a whole hour webinar. And most of the time, not always, but most of the time we see guardianship of the person, not necessarily guardianship of the estate. So you guys can educate yourself on that on our YouTube channel and kind of check out the guardianship webinars on that, because there are some unique differences there for sure.
Yeah.
Allison, we have some questions in the Q&A. I don't know if you already answered one those, I think, or not. Can you open the Q&A?
Yes, I think we've addressed most of those questions. I don't see anything. SSI asks for a rent agreement, bank records, and first-party special needs trust documents. Yes, and that is normal. And what's also normal is that they ask for it and then they never, ever review it. You send it in and you never hear back from them. Like I think we sent ours in 3 or 4 years ago and I never heard back from them. So that is also normal. But the rent agreement for SSI, so basically if you don't have a rent or a fair share agreement, again, there's a whole presentation on SSI and Medicaid and SSDI. But basically, when you apply for SSI for the first time, you get this amount like $522 or $500 and something. If you're getting $500 and something, you can get the full amount. And to get the full amount, you basically submit a rent or a fair share agreement showing that your child is paying rent. When their check comes in every month, then you move that rent amount, $500, whatever. I think $500 is a good number. I mean, in general, but over to your account to cover the rent. And then you show that rent agreement, and it doesn't have to be like long. And I mean, it could be a 1-pager. We have some templates for that, but you show that to them and then they'll increase their benefit to the full amount for the SSI. So that's something else. Again, we can help with those types of things. But if you're getting a 500 amount, your child is not working and you're getting some 500 amount, you need to submit the rent or the fair share agreement to get that number increased.
Yeah.
Okay, let me see if I see anything else here. Yep, and someone said that their rental agreement did get them the full amount. Okay, let's see. Okay, so I think that's it for questions right now. We can go to the next slide, I think. Oh, there you have it.
it.
So the next slide. So one of the things that we talk about on a pretty regular basis is, some of the things that should be on your radar. Like I said, I say we're a broken record, but honestly, we can't say it enough because we want to educate you and put the tools in your hands. So that way you can be successful in your journey with special needs. But, your beneficiary designations, those things matter. Not naming your special needs child directly as a beneficiary, naming that special needs trust is really, really important, making sure other people do the same thing. But I would also argue that naming a minor child, this is another snafu that many, many financial advisors make, is naming minor children as beneficiaries. And usually what people do, and if you did this, don't beat yourself up, you can fix it for free. To change a beneficiary form, you can totally update this. But a lot of times what people do is you have husband and wife and they're each other's beneficiaries. And then they say, well, if I die and he's dead and gone, then that's easy. The kids are going to get the money equally. That's a pretty common thing that people do, and financial advisors wrongly allow you to do that. So basically, when you do that, and if you die, your spouse is already dead and gone, and you name your minor children, neurotypical minor children, that money's sitting in trust for them until they turn 18. And the bad news is that child is getting all that money when they turn 18. And I know your children are brilliant, just like mine, but most children cannot handle large sums of money. It's usually a pretty bad idea. So if you're taking notes, we always say, check your beneficiaries. I'm talking about 401ks, 403bs, life insurance through your work, life insurance outside of your employers, anything that can have a beneficiary, transfer on death or payable on death on your bank accounts at Chase, Bank of America, Wells Fargo, wherever. Check all of those things. It's real important. The other thing that I would also mention, I like to mention this on a regular basis. We want you to have intentional conversations on those power of attorneys and healthcare power of attorneys. Number one, are yours in place? But what about your aging parents? Are their powers of attorney, healthcare powers of attorney? Are they in place? It's real important. And the last thing that a lot of people forget is I recommend all of our clients have that power of attorney and healthcare power of attorney, whether it's, in place right now or it is in place when they become incapacitated. You guys can figure that out. But for your kids that are going off to college, it's a real important document to have. They turn 18. And if something happens to them, they get sick. I had a client that's child went to the mental hospital. They wouldn't talk to her. So, these are examples of why you might want to have some of those documents. So those are just a few of the things, reminders that we like to share with people. And for that, Melissa, do you have anything else that you would want to add or share on that?
I don't think in that realm. You've kind of covered all of my bases here for me, Allison. But it is a good idea. We do that with our clients all the time, because I don't know if this happened to you when you were in college, but I remember the first time I tried to get my mom to schedule my doctor's appointment my freshman year in college. And I wasn't very happy when I couldn't let her do it for me. So it's just a good idea. Like Allison said, you've got a kid going off to college. They turn 18 senior year in high school. Simple powers of attorney so that you can, kind of like you can still continue being mom and dad. So important things
for sure.
To have in place. And it is important to have, again, those conversations with other family members about your special needs child, because not everybody is going to be as entwined in this stuff as you are. You're their parent. So it's important that the rest of the family knows, because more often than not, they have the best of intentions and they just want to help and they love their niece or nephew, but they want to make sure they're doing it the right way. So that's the thing that I tend to harp on a lot with my clients, is make sure you're having those open conversations with your family members, because it is really important that you don't do everything you need to do and have someone else throw everything off.
For sure. And I think those intentional conversations, we've seen with some families that we've worked with where they've had family members that had like massive middle brain strokes and they were incapacitated completely. However, they did not pass away, where some of these documents weren't in place. So, have conversations when people are of sound mind and body. And even if you have family members that keep their cards pretty close to the chest, you don't have to know the numbers. What we share with is starting the conversation is, Mom and Dad, we've been, working on, setting things up for our family from a special needs perspective for little Johnny. And we learned the following things that we didn't know, and we didn't know if you knew this either. And we wanted to share this with you. Because the thing is they're leaving money because they want to help. They don't want to mess things up. And so kind of positioning it that way and not having to know the details of assets and things like that, where they're, very hush about. I'm assuming nothing. I'm not saying that you ever plan to leave anything to little Johnny, but I just wanted to let you know that if you intend to, here's the right way to go about doing this. We've set up this special needs trust, and here's how you can do it. And so I think that those conversations work for sure. Well, we're done, and we're done a little bit early. Veronica, as usual, it is a pleasure being with you today. And Melissa, thank you. Thank you for being awesome. Melissa can be reached. You can see her information on the screen. What counties, where are you located, Melissa, and what counties do you serve in particular? I know we've got people from all over the state on here.
Yeah, so our main office is in Austin, and generally we serve Central Texas. So our main office is in Austin. I like to kind of say we're just north of downtown. When I say downtown Austin, it kind of scares some people. So we're just north of downtown Austin. We do have some satellite offices that we meet clients by appointment only. We've got one in Georgetown, one in Horseshoe Bay, and one in San Antonio. Sometimes we are able to help clients further out in the state. We have some clients relatively far away. I say relatively because I'm originally from Massachusetts, so far to a New Englander is a little different than far to a Texan. But we can help a lot of people, but generally speaking, most commonly our clients are in the Central Texas area, ranging from San Antonio to Waco area out to Horseshoe Bay.
And so basically speaking, even if they're not in that area, you can help them with a special needs trust per se, but maybe not guardianship. Is that right?
Yeah, so what I usually will recommend to clients, because I've had a couple of people who have contacted us about guardianship, and I'm happy to speak with them, but my usual advice to them is it's best when dealing with guardianship. And this is one of those things, when it comes to guardianship, you're dealing with the court. And there is some truth to the old adage of a good lawyer knows the law, the best lawyer knows the judge. This is a little different than if you're dealing with more of a litigation type thing, but it's easier to work with someone who is very familiar with the court system, who's close by. So generally speaking, my advice to clients who are further away is if you're looking at guardianship, it's best to work with an attorney in that area. That's not to say we couldn't do it, but it usually is not that advantageous for the client. And as much as we might not think so, as an attorney, I do actually think that my job is to do what's most advantageous for the client.
And I know for us, and I know for you too, we're happy to make referrals. We do have attorneys that we know do a great job all over the state. So if you're not in that particular area and you're saying, oh my gosh, I need somebody good, we're happy to make a referral that way. And I know Melissa is too. So thanks so much, everyone, for being here today. Thanks for taking your time with us over the lunch hour. And we will certainly be back with you again. Thanks, everyone.
Thanks. Bye-bye.
Stop the recording, and I will send you an email later today with the information that Melissa and Allison got for us. So thank you so much.
Take care. Bye now.